Some of the most powerful laws ever passed in the United States were not celebrated. They were protested, challenged, and in many cases, eventually dismantled entirely. And yet, while they existed, they shaped the lives of millions of Americans in ways that still echo today. At least 27 major federal laws have been either partially or fully struck down by the Supreme Court since the nation's founding. 27 laws that Congress passed, presidents signed, and courts later declared unconstitutional or fundamentally unjust. That number alone should tell you something important about how fragile the line between law and injustice truly is. In the next 10 minutes, you are going to walk through the most controversial laws in American history, legislation that divided the country, sparked open rebellion, went to the Supreme Court, and in some cases redefined what it even means to be an American citizen. We will cover everything from laws that legalized human enslavement to laws that imprisoned people based on their ethnicity to laws that censored the press during wartime. And at the end, we will look at one deeply uncomfortable truth that most legal historians rarely say out loud. Let us start at the beginning. Not the beginning of controversy, that would be the founding itself, but the beginning of codified legal injustice at the federal level. Background: the United States was built on a legal contradiction. The Declaration of Independence declared that all men are created equal. The Constitution that followed protected the institution of slavery in 3 separate clauses. The 3/5 Compromise counted enslaved people as 3/5 of a person for the purposes of political representation, not because lawmakers thought enslaved people were partially human, but because Southern states wanted more congressional power while simultaneously denying those same people any rights whatsoever. That is not ambiguity. That is deliberate legal architecture designed to preserve inequality. The Fugitive Slave Act of 1793 was one of the first truly controversial federal laws. It required citizens in free states to actively participate in the capture and return of escaped enslaved people. Not just tolerate slavery, participate in it. Northern states responded by passing personal liberty laws designed to obstruct federal enforcement. The conflict between state and federal authority that would eventually lead to the Civil War began, in many ways, right here, with this single statute. By 1850, an even harsher Fugitive Slave Act replaced it, imposing heavy fines on anyone who helped a runaway and denying accused individuals the right to a jury trial or even the ability to testify on their own behalf. Main content: the Alien and Sedition Acts of 1798 represent one of the earliest and most alarming assaults on the First Amendment in American history. Passed under President John Adams, these 4 laws made it a criminal offense to publish false, scandalous, or malicious writing about the government or its officials. In practice, that meant criticizing the president could land you in federal prison. Several newspaper editors were prosecuted. One congressman, Matthew Lyon of Vermont, was sentenced to 4 months in prison for writing a letter criticizing Adams's handling of foreign affairs. He was re-elected from his jail cell. The Sedition Act expired in 1801, but it set a precedent that the government would revisit more than once. But here is what nobody talks about. The legal tools used to silence dissent did not disappear with the laws that enabled them. They were refined, repackaged, and redeployed in every major national crisis that followed. The Espionage Act of 1917 and the Sedition Act of 1918 were passed during World War I and represented an even broader suppression of free speech. The 1918 amendment made it illegal to speak, print, write, or publish any disloyal, profane, scurrilous, or abusive language about the United States government, the Constitution, the military, or the flag. Over 2,000 people were prosecuted. Socialist leader Eugene V. Debs was sentenced to 10 years in federal prison for giving an anti-war speech in Ohio. The Supreme Court upheld his conviction in Debs v. United States in 1919. The Espionage Act of 1917 remains in effect today and has been used to prosecute whistleblowers in the modern era. The 18th Amendment and the Volstead Act, which together established prohibition beginning in 1920, gave the federal government authority to criminalize the manufacture, sale, and transportation of alcohol. The result was not sobriety. It was organized crime. Al Capone's operation alone generated an estimated $60 million annually in today's equivalent value. Corruption of law enforcement became so widespread that entire police departments in major cities were effectively on the payroll of bootleggers. Prohibition was repealed in 1933 via the 21st Amendment, making it the only constitutional amendment to be repealed in its entirety. It remains the clearest example in American history of a law creating more harm than the behavior it was designed to prevent. Deep Dive Executive Order 9066, signed by President Franklin D. Roosevelt in 1942, authorized the forced relocation and incarceration of approximately 120,000 Japanese Americans living on the West Coast. Two-thirds of them were American citizens. They were given days to dispose of their property, businesses, and possessions before being transported to internment camps surrounded by barbed wire and armed guards. The Supreme Court upheld this policy in Korematsu v. United States in 1944, ruling that the need for national security outweighed the civil rights of an entire ethnic group. That ruling stood as precedent for decades. It was not formally repudiated by the Supreme Court until 2018, in Trump v. Hawaii, when Chief Justice John Roberts explicitly stated that Korematsu was gravely wrong the day it was decided. What does it say about a legal system when its highest court takes 74 years to acknowledge a catastrophic moral error? The Jim Crow laws, a collection of state and local statutes enacted primarily between 1877 and the mid-20th century, legalized racial segregation across virtually every aspect of public life. Schools, hospitals, restaurants, transportation, voting, and even water fountains were divided by race under penalty of law. The Supreme Court's decision in Plessy v. Ferguson in 1896 provided the constitutional cover for this system by establishing the separate but equal doctrine. That doctrine remained the law of the land for 58 years until Brown v. Board of Education in 1954. The Civil Rights Act of 1964 and the Voting Rights Act of 1965 were required to dismantle what law had built. And even today, challenges to the Voting Rights Act continue to reach the Supreme Court with regularity. Analysis: what makes a law controversial? It is not simply unpopularity. Many laws are unpopular. A law becomes truly controversial when it forces a society to confront the gap between its stated values and its actual practices. Every law on this list did exactly that. The Fugitive Slave Act exposed the lie that the United States could be both free and slaveholding. The Sedition Acts exposed how quickly democratic governments reach for censorship when their authority is challenged. The Internment Executive Order exposed how race-based fear can override constitutional protections even in a nation that claims equal protection under the law. The Jim Crow system exposed how legal language, separate but equal, can be used to dress up systemic oppression in the language of fairness. There is a pattern here that every American should understand. Controversial laws are almost never passed by people who believe they are doing something wrong. They are passed by majorities who have convinced themselves that necessity, security, or order justifies the temporary suspension of rights. And the word temporary almost never means what it promises. The legal legacy of these laws is not simply historical. The Espionage Act is still prosecuting people today. Voting rights battles rooted in the unfinished work of Reconstruction are still being litigated in federal courts. The mechanisms of mass detention established by Executive Order 9066 were never constitutionally dismantled, only politically abandoned. Conclusion: American legal history is not a story of steady progress toward justice. It is a story of contested ground, hard-fought reversals, and recurring cycles in which the government reaches for extraordinary power and the courts, sometimes quickly, sometimes after decades, pull back. Every controversial law on this list was, at the time it was passed, considered by its supporters to be reasonable, necessary, and constitutional. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Eagle Brief for a brand new video every single day. We will see you in the next one.